So number 4, we kind of touched on when we were talking about the assets part, the assets in the probate, right? So, I like to use kind of these stories. You have this person with 3 kids, good, bad, and medium. Say this person, passed away with $3 million, IRAs, 401ks, life insurance, all stuff that you manage. House, cars, bank accounts, brokerage accounts, some annuities, some CDs, CDs that are crushing it, paying like 0.0002%.
They're doing awesome right now.
Hideout for 5 years. Those kinds of big winners. Say there's that kind of an array of assets. If you don't have a handle on it, and you and I aren't able to talk about it and kind of work through it quickly, like that's a process to figure out, to get these institutions to respond, give information. Once they confirm, get the court order, send them to them, have them send the paperwork to transfer it. You need to have someone like Chad, like you, working on this together, or else it's a real pain in the butt, and it will be expensive.
You talked about assets and figuring out where they are, how much they're worth. Most really, really successful people, their largest asset is their business. And I'd imagine, determining, unless they're doing the proper planning all the way along, working with people like us, it might be pretty difficult for them to ascertain relatively quickly what the value of their business interest is worth. Have you encountered a lot of situations like that where someone passes away and they haven't done proper buy-sell planning, which is something that I thoroughly enjoy and was one of my hot items on our last our last video. So I know how to plan for that ahead of time. But how difficult is it on the back end to ascertain the business interests and kind of divvy that up from an estate standpoint?
So jumping to number 11, which I'm going to bold because I get fired up talking about this issue that you bring up. First of all, I love business. Anything business, I love it. I want to talk about it all the time. So when it comes to businesses and estate planning, businesses and probate, it's an important point to talk about. So forgive me if I get a little excited. When you pass away and you own a business in your name, if you don't have proper documents, your management team has kind of just lost its leader. And legally, the personal representative, the executor, very well may be your successor. And that's not happening overnight. So you actually could have a disruption in your business until that does happen. And then, of course, your personal representative / executor is now running your business, which may be a good idea and maybe a terrible idea, depending on...
I'd imagine most times they have no idea what the business is or how to run it.
Yeah, a lot of the times I would say in estate planning, when you have a married couple, it's the spouse. So think about whether you want your spouse managing your business. It's nothing, negative about the spouse. It's just that they're probably not involved, typically not involved, and typically they don't have the relationship with the other partners. And so there's like that disruption right there. You have a different legal manager now, and that's one issue. Another issue is that now you have an asset. So I deliberately skipped this one on my list of assets I mentioned earlier. But say in addition to all those other assets, you have a business. That business has a value, right?
Yep.
How do you determine value? Who determines value? The PR? The PR doesn't know anything about business. They don't know how to value it. They're not a professional, valuation company. So who does it in your experience?
In my planning, it's not done on the back end. It's really done on the front end. It is some sort of professional who specializes in doing business valuations. There's quite a few methods that they can use. But really, it's important the same way to work with, I guess maybe that can be part of the triumvirate, but really a subdivision of the triumvirate, really having a business valuation specialist for your business. it's important to have that updated as your business grows. Also, you don't want to have an outdated valuation on your business if you've increased substantially over the years.
Yeah, so let's talk about that. It's a great point. So take the first part is like the valuation. Like, what is the valuation? Then take the part about like, what happens if your valuation, you did some planning, but it's wrong. So in the first case of dealing with valuation of business, like you mentioned, professional valuation companies exist. It's an art and a science. I'm fascinated by how they do it. It's not cheap. Well, of course, you're like, oh, it's expensive. I don't want to do it. We'll just go, what's a cheaper way to do it, right? We'll just go get a broker. The broker will tell us. Okay. Well, now you're in the cage fighting situation. You're in the arena. The cage match is in the arena of the cage match. And there's creditors and there's beneficiaries. And there's people who have rights in the estate. And they don't like your valuation, because that means they get less if it's a percentage, or they don't feel comfortable that your resources or your person you hired is qualified. So you're going to start getting multiple valuations, and you're going to be inevitably fighting over the valuation. And the judge, again, this recurring theme of this judge stepping in to make decisions for you, now is telling you how much your business is worth.
I'm sure he has tons of experience in valuing businesses.
Yeah, right. And so you have this problem. I've seen it actually in a case of a beneficiary, the IRS as a creditor, and I guess another creditor trying to bring assets back from a fraudulent transfer, but all complaining over the valuation that was done. And it was a lot of money spent on an estate that had very little real assets, real value. So that's issue number one. You're really putting your business in a blender if it goes through probate. Second issue you mentioned was, on your front end, you're doing valuation, and you're planning. So your business is great. You're starting out, you're doing well. You do $1 million valuation. So you do buy, sell life insurance funded. That way, if someone passes away, tell me if I'm saying this wrong, but someone passes away, the life insurance kicks in, buys out that deceased partner's interest. The surviving partners keep, that interest that was just purchased by way of the life insurance, and the company cruises along forward. That's how it works, right?
And the family gets what they're supposed to get.
Family gets a value that was, quote, the fair value of that deceased shareholder's share, right? Okay. What happens if before death, the valuation is now 10 million and your buy sell is 1 million? What happens?
Issues.
A lot of problems. I mean, there's a lot of issues there, right? I mean, what do you do? The family is not going to be happy that there's $9 million they're not getting.
The remaining partners won't be happy either, because very likely that someone in that family is going to be part of the business.
Well, that aside, I mean, just if you have a buy sell that basically says that you have $1 million valuation, and you're not building into the framework the possibility that the business could be worth more later, please call Chad and me today, right now. Do not even listen to any more words and pick up the phone, because that's a disaster waiting to happen. So more likely than not, if you have a good business succession plan, you have good buy sell planning, it will address the contingency where you have like a framework where there's insurance, it uses insurance. If there's a deficiency in the insurance coverage, it does it a different way, right?
Yep.
And so that way everybody gets the fair value. Now, again, it goes back to value though, right? And it goes back to value and fighting over value in the cage fighting match. So I think that addresses those two issues. You really got to plan ahead. You really have to be flexible and have a framework, and you really want to get it out of the court system so that you don't have disruption. The business is a big deal. We talked about it a lot, so I won't belabor the point. I will wait for your next cue.
Sure. We've talked a lot about things that go into probate and ways to avoid it. And you mentioned there's lots of accounts with different beneficiary designations that would, bypass probate. But what happens, in a scenario where beneficiary designations haven't been updated, or you got married and you never really thought to update your beneficiary designation former spouse. How do the courts look at that, and what are some of the consequences in terms of taxation, and in terms of who may ultimately end up getting the money?
So a lot in there.
I think I'm seem to be very good at asking loaded questions for it.
Let's spaghetti you through with the ball there. If you get divorced, the law does treat that person as being predeceased. Usually your settlement agreement and your final judgment incorporating your marital settlement agreement will have something to that effect as well. If you want to give your former spouse something again after you get divorced, that's fine. You're gonna have to do some planning though. Excuse me. I would say one of the biggest things that gets me crazy, and I'm gonna bold it now, is not being attentive. It's not even about just not having a beneficiary designation on those accounts, but it's just not being attentive to them. So, for example, just to be clear, we're talking about assets that have a beneficiary designation: IRAs, traditional, Roth, SEP, doesn't matter. 401ks, 403bs, life insurance, annuities. Those are types of accounts where you can designate that someone is to inherit it by contract, by law, by contract. You show a death certificate, they start the paperwork. There's no court, there's no toll booth. If you screw that up, you're going to have to go through the toll booth. You're going to go through probate. Now, there's two main problems with that. And this is
That'd be
incredible.
not having batteries in your SunPass, for those that have the old school ones.
This is like not having batteries in your SunPass, getting a flat tire right before it goes out, fixing the tire, going into the toll booth. The toll booth person is leaving for the day, so they close up the booth. You got to now go in reverse and get in line. It's a disaster. So what happens is two main bad things. Number one, well, three things actually. Number one is that the person who you probably wanted it to go to is not going to get it, or they're going to get less. Okay. Secondly, it's going to go through the toll booth of probate, and that means it's now subject to the creditors. The ABCs, the C's creditors. If there's creditors, you're bringing an asset that previously was exempt from creditors is now on the table because it's a probate asset. It went from non-probate asset character to a probate asset, and now it's on the table to be taken away from the surprise beneficiaries. And third, and I think this is probably equally as important, if not more important than the second thing, is that you get an adverse taxation issue now. Well, the law previously, before the Secure Act, chime in here if I'm wrong, prior to the Secure Act, spouses could roll it over for their lifetime, and spouses could roll it over Roth forever, right? And then non-Roth, regular traditionals, they could roll it over for their life expectancy. Because if you were to give an IRA to a 10-year-old, their RMDs, the required minimum distributions, would be much less than if the beneficiary was 84, thus allowing it to grow over time. And be
multiple beneficiaries, and one sibling was a lot older, that could be another issue, because the younger one would be paying tax at the higher one's age.
That should be on here as another thing, because when you do your trusts to kind of play that, games with that, you're right. The pooled trust with the elder Benny does trigger the RMDs are at that person's age, even as younger people. Trust for, I'm adding to the list. We're now at 13. So going back to the issue of pre-Secure Act, you could stretch it out. Post-Secure Act, I believe the spouse can still take over, roll it over. But the non-spouse beneficiary now has to max out by 10 years. They have to liquidate the whole thing and pay taxes on it at most in 10 years. And correct me if I'm wrong, but the RMDs are not actually spread over 10 years. The RMDs are actually life expectancy, whatever that is. But you got to liquidate at the end of 10 years to avoid penalties. Now, if it goes to the probate court, there's an accelerated liquidation date. And so now you got to take it out even sooner. And there's taxes. So this is a mistake. Don't make the mistake of thinking that everything is good. Check them often. We make sure that everybody, we work with the financial planners in what Chad calls the triumvirate. But actually we call it the trifecta. Either way, it's fine. We work with Chad to make sure that these things are right, because people make mistakes. We're human beings. And so those mistakes have consequences, and you just want to make sure that everything is the right way. So that's a good one. I get excited about that. Thanks for bringing that up.
Absolutely. We spoke about the next one and difficult family dynamics. I don't know if there's anything you want to elaborate on that. But I think the biggest one really is when you have the good, the bad, and I guess the medium, as you say, and who's fighting for control of either finances or who's taking care of the parent. I think that's we talk about that fairly extensively.
We're in Florida. We're in South Florida. I want to add to that because it's down here. It's so prevalent. In your situation where you have good, bad, or medium, and medium's like playing politician, and sometimes they're on the fence in favor of good, and sometimes they're supporting bad. What the issue is that the elder parents are like political footballs. They're in the middle of a tug of war of control over the kids. Who has control of the money? Who's getting what? Who has control over visitation? Believe it or not, that's a big deal. Who has control over who the parent is seeing, spending time with? Because, one kid has the ability to influence the personality of the parent the more they're with them. This is where maybe guardianship could be beneficial, to have kind of a neutral person in the middle. Elder abuse doesn't just mean physical. Elder abuse could be emotional, psychological, financial, medical. I've seen some really disturbing things in my day, and I've only been practicing for 12 years, and I've seen some crazy shit, quite frankly. So elder abuse is real. There's a new Florida statute.
On the financial side, there's special rules in terms of different vehicles that an elder may be going into. Even on the financial professional side, certain obligations that we have to abide by because there is elder abuse that goes on.
Yeah, there's a statute now on it that defines what it is and provides remedies for it. So it's really prevalent down here. It's very sad.
Haimo